All right,
Stand or sit.
at the table is fine. We are on the record. In file number 21-48488-UN, Frankie Spina versus Bradley Barnhouse. We are here today for a show cause hearing. Sir, you are Bradley James Barnhouse.
Yes.
Mr. Barnhouse, it indicates here that you have you have a monthly child support charge of $150 and that you're currently behind in the payment of that support in the amount of $1,736. Do you understand that, sir?
Not that number. That's actually why I came in person.
All right. So I'm advising you now that the allegation is that you have a arrearage of $1,736, according to this information. Do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
I understand that, yes.
Do you understand that if you were to plead guilty to this charge that I could sentence you in jail for up to 30 days?
Yes.
You are entitled to have an attorney represent you here today. And if you can't afford your own attorney, you can tell me that now and I will appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
I don't really necessarily need one, I believe, for the situation currently.
All right. Do you understand that you are entitled to have a trial on this matter and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt?
Yes.
You're entitled to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you have the right to have me order any witnesses that you have for your defense to appear at your trial. You understand that, sir?
Yes.
You are not required to say anything at your trial, and if you don't say anything, no one can hold that against you in any way. Do you understand that as well? And you are also entitled to testify at your trial if you wanted to testify. Do you understand that?
Yes.
How would you like to plead to the charge that you failed to pay child support to the very best of your ability up to the amount ordered?
Not guilty, as I have tried to the best of my ability when it comes down to it. Currently, I have a major discrepancy in the numbers that I'm trying to figure out, and that arrearage should be 100% paid off and then some by my taxes as of within the last month.
So you made a payment within the last week?
Within the last week, I've received my federal tax return garnished by $230 over the amount that I have records saying I paid.
Okay. So what I'm going to do, well, let me ask this, Ms. Stevenson, do your records yet reflect any tax seizure payment?
I am looking for the last payment right now. The last
Okay.
payment we received was on January 6th, and it was $300.
Okay. So it might just be an issue of the systems updating for that payment to reflect in the front of the court
With that,
records.
there's a lot of confusion on my end involved in this, as records stating, you said 1736 was the amount?
Correct.
As of January 6th, my record stated that there was 1436. As of February 14th, record stated I owed 1586, and now it is suddenly 1736. These numbers.
Well, there's a monthly charge, so the difference between the last January number that you had and the February number would include an additional $150.
Yes, that should be the February amount owed, right?
Correct.
So where's the other money to make it go up to 17?
I can't give you an accounting of that. That's not, I don't have that kind of
It's
detail.
just something that's
for purposes of today. So what I'm going to do, because you have indicated that there was a large payment seized from your taxes, is adjourn this hearing for a couple of weeks. And hopefully by that time, the accounting systems will catch up and it will reflect that payment, and we can figure out where things stand. So I'm going to set this out to March 20th at 8:15. And you can come either in person as you did again here today, or you can attend by Zoom if you prefer that.
I kind of prefer the in-person Zoom, just.
Yeah, whichever you want to do is fine. And in the meantime, I would encourage you to get in touch with the friend of the court and go over your records with them. Because they have the detailed payment information and,
Yes.
and you know.
I
when the charges
understand
are
that
made.
in the courtroom is a little less. I wanted to bring that up as a subject as it's like there's money just keeps getting tacked on that is more than the 150 monthly value, and I'm wondering where those charges are coming from.
All right, so you would need to talk to your enforcement officer about that issue. And then if it's still an issue after you speak to her, then we can address it here. But again, in the meantime, we're going to set it out to March 20th so that hopefully at that time their computer system will reflect your payment. And it sounds like if what you're saying is accurate, then we probably don't have an issue to go forward on. So, so again, March 20th at 8 a.m. Okay, we'll come back at that time. We'll see where we stand.
Am I good to go? Or
Yep, you're all set. Thank you very much.
thank you.
Okay, we can start the record on Baber versus Stickler. So we are on the record in Tiffany Baber versus Stephen Stickler. It's file 22-49215-DC. Today is the date set for a hearing on an order to show cause. Sir, you are Stephen Cole Stickler?
Yes, Your Honor.
Mr. Stickler, according to the information I have, you have a monthly child support charge of $376, and there is currently an arrearage in the amount of $4,720.50. Do you understand that, sir?
Yes, Your Honor.
Do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes, Your Honor.
Do you understand that if you were to plead guilty to this offense, that I could sentence you in jail for up to 30 days?
Yes, Your Honor.
You are entitled to have a trial on this, and you cannot be convicted unless the evidence at your trial proves that you are guilty beyond a reasonable doubt. Do you understand that?
Yes, Your Honor.
You're entitled to have an attorney represent you here today and at any other proceedings we might have on this matter. Do you understand that?
Yes, Your Honor.
If you want an attorney and you don't have the money to pay for one, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes, Your Honor.
Would you like to be represented by an attorney?
It sounds like I'm being charged with something. I've worked child support out with Miss Baber. I was at her house for 1 month working on stuff for her. I took everything off of work to do it. I had messages and stuff.
Mr. Stickler, I'm gonna stop you because I need to advise you that you are being charged with something. It's a contempt of court for which you could ultimately serve up to 30 days in jail. In a moment, I'm going to ask you if you want to plead guilty or not guilty to that. But first, I need to know whether you want to be represented by an attorney.
Yes, Your Honor, I do.
Okay. Do you have the ability to pay for your own attorney?
No, Your Honor, I don't.
Okay. So I will appoint the public defender's office to represent you on this. We don't have someone here right now, but I expect our public defender to be logged in shortly. So I'm going to place you back in the waiting room, and as soon as she gets here, I will have you speak with her.
Thank you.
Okay, good morning again, Mr. Walters. I was just looking at my notes. Had you previously had the Public Defender's Office appointed to represent you?
Yes, sir.
Okay. I'm gonna have to put you back in the waiting room then. Our public defender's not logged in yet. I think she's handling cases in another court right now. So as soon as she gets logged in here, I will bring you back in and we'll get your hearing taken care of.
All right. Thank you.
Okay, good morning, Mr. Murphy. Are you here for any particular case?
Your Honor, I thought I saw on the jail sheet, Mr. McCray down at sentencing left over from the 23rd. It wasn't on my docket, but I saw it on the jail sheet, so that's why I was appearing, because that wasn't my case. I didn't know if you had it somewhere or not.
Yeah, he was on the jail sheet, but I'm not sure why. I don't know yet how we're gonna handle the stuff from Thursday and Friday.
All right, well, just contact my office because I'll be down in district court. So please just I'll be available if you need me to come up there. So thank you.
Okay, sounds good. Thanks. All right, we are on the record in file 17-44366-DM, Victoria Flores versus Aaron Sabota. Sir, you are Aaron Sabota?
Yes, sir.
Mr. Sabota, had you previously had Ms. Underwood from the Public Defender's Office represent you?
Yes, sir.
Okay, so I'm going to place you back in the waiting room. Ms. Underwood's not logged in yet. I think she's over in the other court handling cases there. As soon as she gets back here, I'll bring you back in and we'll get your case started.
Okay.
All right, Mr. Morris, are you there?
Yes.
Okay. We're on the record in Natasha Taylor versus Curtis Morris, file number 09-33650-DM. We're here today for a hearing on an order to show cause. Sir, for the record, you are Curtis Morris.
Yes.
Mr. Morris, it states here that you're ordered to pay $705 per month in child support, and you currently have an arrearage of $2,409.34. Do you understand that?
I do and I don't, because it's actually it's been getting deducted out of my pay stub, my paychecks, which I have proof. So what is going on is I have another child support that I'm paying in Oakland County.
All right, Mr. Morris, I'm going to interrupt you. Before I let you talk too much, I need to make sure that you know what your rights are, all right?
Okay.
So I'm going to ask you a few questions to make sure you understand your rights. And then if you want to give me an explanation about what's going on, you can do that.
Okay.
So do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes.
Do you understand that if you were to plead guilty to this offense, that could sentence you to jail for up to 30 days?
Yes.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes.
You're entitled to have an attorney represent you here today and at any other proceedings that we might have on this matter. Do you understand that as well?
Yes.
If you want an attorney and you don't have the money to pay for one, you can tell me that now and I'll appoint one for you at public expense. Do you understand that?
Yes.
Would you like to be represented by an attorney?
No, I have enough proof to show.
Okay. So you currently have payments being taken from your paycheck?
Yes. So the amount that I agree to, that's a signed document, is $371.72. That's supposed to be taken out my paychecks every paycheck, which has been happening. I have whatever date y'all need. It literally shows.
All right. Let me ask. So you said the amount taken out is $371?
$371.72 each paycheck.
Okay, so that how many paychecks do you get a month?
I get paid bi-weekly.
Okay. All right, so Ms. Stevenson or Mr. Anderson, do we have any information on his income withholding order?
So I believe what's happening, Your Honor, is that almost half of his payments are going to the other case.
Correct.
I believe it's Oakland County. Yeah.
Correct.
All right, so Mr. Morris, you need to make payments that are sufficient to cover all of your cases.
No, so Your Honor, I also have agreement.
Mr. Morris, I'm not here to discuss or debate that subject with you. You have in this, Mr. Morris.
Yes, I'm listening.
You have a monthly obligation in this case of $705. That is not being met because part of what's being taken from your paycheck is going to a different case. And so the monthly charge in this case is not being satisfied.
Your Honor, may I be able to speak, please?
I'll advise you again that, well, let me go through a few other things before you do that.
Yeah.
You understand you're entitled to have a trial, and you're entitled to have all the witnesses against you appear at your trial, and you have the right to ask those witnesses questions or have your lawyer ask those witnesses questions if you have a lawyer.
So Your Honor, I'm gonna request a trial because I already spoke to the FOC officer at Linway County, and he knows what's going on, and he's actually was supposed to cancel this. So what is going on is, for some odd reason, I have no control over it, that my payments is getting taken from Natasha, which I have a great relationship with her, from her, and they're double paying Oakland County by mistake. It's a error on friend of the court. So it's not my issue. So if we need to go to trial, we'll go to trial. Because I already have a agreement. So 380 is going to Oakland County, which the agreed amount is, and it shows it on my pay stub. And 371 is supposed to go to Linway County. For some reason, whatever's going on, they're doubling her amount. They're giving her the 371, which she should not be getting. I should not be getting penalized on something that's not my fault. And again, I have been paying 371 for the past 15 years. Whatever amount y'all stated, I always been paying it. It comes out of my paychecks directly. Now, since I have another child, it for some reason it stopped, and they're sending all those payments to Oakland County, which she should not be receiving. That's what's going on. So if I need to do a trial, I'll do a trial.
All
And I'll
right,
give
Ms. Andrews, can you tell me the next date that Mr. Brugman's going to be here on a Tuesday for paternity cases?
March 7th.
Okay, so he'll be back on the 21st. So I'm going to set it for March 21st at 8 a.m. So I'll enter a not guilty plea for Mr. Morris, and we'll set a trial date of March 21st at 8 a.m.
Excuse me, Mr. Bergman is not available on the 21st.
Okay, so we'd have to go to April 4th.
Correct.
In your honor, friend of the court was supposed to contact you and cancel this date. Because he said he was supposed to reach out to Oakland County to get it figured out. He said, I see what's going on, and it's an error on friend of the court. So,
All right. Well,
yeah.
Well, you'll need to contact your enforcement officer, and if you can work through that issue by April 4th, then we won't have to have a trial. But as it stands right now, we're scheduling the trial for April 4th at 8 a.m. And if I need to resolve the issue with a trial, then that's how we'll have to handle it.
Okay. And does the other mother get penalized for accepting money she's not supposed to accept? Why am I getting penalized on something I'm paying? It comes out of my check. I have no control over where it gets dispersed.
First, I don't know enough about your. First of all, I can't give you legal advice.
Yeah, I know.
Secondly, I don't know.
It just
Mr.
messed
Morris,
up. I'm doing everything I'm supposed to do.
All right, so Mr. Morris, I've muted your device because you have continually interrupted me throughout the course of this hearing, and you're not allowing me to conduct this hearing in a reasonable fashion. So I'm not going to have any further discussions with you right now. I'm setting the trial date for April 4th at 8 a.m. You can attend that hearing by Zoom as you've done today, or you can attend in person. And we will get a notice of that hearing to you sent as well, but it's April 4th at 8:15. You can go ahead and log out.
Thank you.
All right, Ms. Underwood, we have Michael Walters here, who you have been appointed on previously.
Thank you, Your Honor.
Do you need a breakout session with him?
Yes, please.
Okay. Okay, good morning, sir. Are you Matthew Summers?
Yes, sir.
Okay, Mr. Summers, your hearing has been adjourned to April 3rd.
Okay, awesome. Thank you. Will I get something in the mail for that? Or should I write that down?
You should get something in the mail, but it probably wouldn't hurt if you wrote it down too. It's April 3rd at 8 a.m.
April 3rd at 8 a.m. Okay, I will write that down. Thank you.
Okay, thank you very much.
Yes, sir. Yeah, bye.
Hello?
All right, Mr. Thomas, if you just want to hang on for just a moment, I'll be with you in a second. I need to call one other case first. So we are on the record now in Courtney Ross versus Michael Walters. It's file 21-48420-DS. Today's date set for a hearing on an order to show cause. We are proceeding by video conference this morning. Both Mr. Walters and Ms. Ross are logged into the video conference session. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Walters this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Walters' case today?
Mr. Walters was last in contact with Social Security a couple of weeks ago, Your Honor. They are in the process, and his lawyer has been notified of that. We're unsure quite how long it's going to take. I would ask that this be put out till perhaps late March, and we see if that has come through yet, Your Honor.
All right, so according to my notes, he was supposed to have filed a petition to modify his child support, which he did, but then didn't appear for the hearing, and that was dismissed. So an issue Mr. Walters is having is that this $330 per month support charge continues to rack up, and the court's required to do something about it. So that issue needs to be addressed properly, and it hasn't been.
I called the court and they said that I didn't have that court date that I missed. I called and the lady at the courthouse said there was no court date until this one, or otherwise I would have been at that last one with the hearing, because I'm the one that went down and filed for it. I don't understand. I keep getting papers saying that court date is closed, and then it's a different date, and then this is the second time you guys said that I missed the date that I was told that isn't even a date. It was postponed to a different date, and I showed up at this.
So let me say this, Mr. Walters. When you file a petition, it states on the petition what your hearing date's going to be, and so you need to show up for that. It doesn't you know, you need to try to show up for that, because it's not a matter of calling the court and having someone tell you a different date. You need to try to show up for those dates.
Yeah, papers saying those dates were canceled.
That's the problem. You need to go by the paper and not by what someone tells you on the phone.
I know they both said the same thing. The date was canceled, and then I just heard you say that I missed a date.
All right, so
I'm sorry, Your Honor.
Well, I don't know, the issue of Mr. Walters' monthly child support charge still needs to be addressed. And that's gonna apparently require him to file another petition with the court to get that done. I'm sorry, Ms. Underwood, you had indicated he is still waiting to hear back from Social Security.
Your Honor, perhaps if we give Mr. Walters one adjournment for both issues, Mr. Walters, you need to properly go down to front of the court, file your petition, and show up on the date that it says.
I did, but I'll do it again.
Thank you.
All right, so I'm going to set this out to April 3rd at 8 a.m. I think it is important for me to state that this will be the last adjournment. If we don't have these issues resolved at that time, I'm going to set it for trial and we're going to resolve the matter that way.
Thank you, Your Honor.
All right, Mr. Walters, Ms. Ross, you can go ahead and log out.
What was were we gonna do anything about the child like seeing the kids?
No, I cannot do that in the context of this show cause hearing. If you have an issue with the visitation, you would need to include in the petition that you're going to file a request to set parenting time.
I did that last time I went there.
You had a hearing on that?
No, I filed the petition down at the front of the court when I filed the same petition for this one to have parenting time scheduled or changed.
All right, well, that, as we discussed, that hearing did not take place. So you need to refile your petition and have your hearing.
Okay.
All right, thank you. You can go ahead and log out. All right, Mr. Thomas, have you previously had the public defender's office appointed for you?
Yes, he has, Your Honor.
Okay. All right, Mr. Thomas, I'm going to place you in a breakout session with Ms. Underwood.
Yeah.
Okay, for the person that just joined the meeting, can you tell me your name, please?
Tabitha Clark.
Okay, 1 second.
Okay.
And what case are you here for?
Versus Richard Walker for child support.
You know your case number, Ms. Clark?
I don't. I actually misplaced my paper. We're in the process of moving. So I ended up calling up to the courthouse and they gave me this number.
Your Honor, if I may.
Yeah, go ahead.
I'm looking at our case notes and it shows that they had a referee hearing on February 6th that was adjourned until this morning at 9.
Yep, I remember that. Yep.
With
Oh,
Ms.
okay,
Garno.
so with Ms. Garno. Okay, so give me 1 second. Okay, so Ms. Clark, you'll want to log out and I'm going to give you a different Zoom ID number.
Okay.
So the one that you want, you have something to write with?
Yes, I do. Thank you.
Okay, so the one that you want is 463
Okay.
742.
472.
No, I'm sorry, 463 742
70742. Okay.
25.
Okay.
I'm sorry, I think I messed that up. How about I'm going to put that in a chat message to you so you can read it instead of me.
Okay. All right. Thank you so much. I appreciate it.
Okay, no problem.
Have a good day. Bye.
Thank you. Okay, we have Ms. Underwood and Mr. Thomas back from the breakout session. Ms. Underwood, where do we stand with Mr. Thomas's case this morning?
Good morning, Your Honor. Mr. Thomas, Your Honor, has applied for disability. Mr. Thomas also, I've explained to him, needs to go down to the front of the court and have file a petition to have his child support adjusted, Your Honor. Mr. Thomas is able to make a $250 payment today, which he will do. And I would ask that we set Mr. Thomas out perhaps to April 1st to allow him to do a petition and to see if he hears from Social Security.
All right, I will do that. I think we also need to get an updated address for Mr. Thomas. So I'll set this out to April 1st on the condition that Mr. Thomas make the payment indicated by Ms. Underwood. And Mr. Thomas, I'll need you to unmute, and I'm going to put you in a breakout session with Ms. Stevenson so that she can get your current address, all right?
Your Honor. I'm sorry,
Yeah.
did you say April 3rd?
I said the 1st, which is a Sunday, so I should have said the 3rd. So April 3rd at 8 a.m.
Which date is it, Your Honor?
April 3rd.
3rd. Thank you.
Okay, so Mr. Thomas, I'm going to put you in a breakout session with Ms. Stevenson so she can get your current address and telephone number.
Okay.
And Ms. Underwood, we have Mr. Sabota is here. Do you need a breakout with him?
Yes, please, Your Honor.
Oh, hang on. All right, Ms. Stevenson, Mr. Sabota, I apologize. I clicked the wrong button and stopped your breakout session. So let me do that once more. That's right. All right, Mr. Thomas, I'm going to send you a request to unmute. Sending a request to unmute, Mr. Thomas. Okay. Mr. Thomas, had you previously had the public defender's office appointed to represent you?
I did.
Okay. Ms.
I
Underwood
don't
is.
know. That was a question. That was a question. I did not know that if that was so.
Oh, all right. Hang on. Okay, Mr. Thomas, you are all set. You can go ahead and log out.
All right, thank you.
All right, we are on the record now in Victoria Sabota versus Aaron Sabota. It's file number 17-44366-DM. We're here today for a hearing on an order to show cause. Mr. Sabota is here by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Sabota this morning, Your Honor.
And Ms. Underwood, where do we stand with Mr. Sabota's case?
Well, Your Honor, Mr. Sabota is working for the Asplin Tree Company. He hasn't had a chance to get into the front of the court, but they can do income withholding. And the tree company is a pretty popular place right now, Your Honor. He's working 16-hour shifts. So I would imagine we can get income withholding started in short order. So I would ask for a short adjournment on this to allow that to happen.
All right, so we don't have any payment from Mr. Sabota since December. Is there anything you can pay now?
Yeah, I'm just waiting on some money from some work last week, some side work I did besides my job, and I should have a payment in today or tomorrow for all of January.
Okay, so that'd be $691 to cover January's.
Yes, sir. And then once my checks are coming in regular and in the full amounts, I'll be able to be caught up with February as well by the end of this month coming up.
Okay, so I'll set this out to March 27th at 8 a.m.
Did you say March 7th, Your Honor?
March 27th
Thank you.
at 8 a.m. On the condition that Mr. Sabota make that $691 payment this week. And then obviously get the income withholding order set up. All right, so you're all set then, Mr. Sabota, you can go ahead and log out.
Thank you, sir.
All right, so Ms. Underwood, I have James Thomas here that you have previously been appointed to represent him as well.
Thank you, Your Honor.
Give me just 1 second. I'll put you in a breakout session with him. Good morning, Ms. Underwood. What case are you here for?
Your Honor, my client Suzanne Larde mentioned that there was supposed to be a hearing on a PPO this morning, but I don't see it on the docket. I'm just trying to figure out if there was something set for today other than their pretrial.
I only see the pretrial at 2:50.
Okay, thank you, Your Honor. Is there any way to figure out whether there's a show cause or any type of hearing on PPO violations for Mr. Larde?
I don't have the ability to do it right now. We would usually do those on Wednesday mornings along with our criminal docket though, so.
Okay, I'll just follow up with the clerk's office and see if they can help out.
All right, thank you.
Thanks, Your Honor.
All right, Ms. Tripp, Mr. Caceres, I'll be with you. Excuse me. I'll be with you in just a moment.
Okay.
All right.
Yes, Your Honor.
Okay, we have Ms. Underwood and Mr. Thomas back from the breakout session. Ms. Underwood, where do we stand with Mr. Thomas's case today?
Rhonda Underwood. Actually, Your Honor, Mr. Thomas and I have never met. I don't believe I was appointed on this case, but in any case, Mr. Thomas has picked up a great deal of work. He does roofing, and he's obviously doing a great deal of work right now. Your Honor, he's prepared to make a $400 payment today, and I would ask that the court allow him to do that and set this out for future payments to come in, because I believe Mr. Thomas will be able to make some payments.
All right, so I apologize. I had seen in the court notes that you had previously been appointed, but that was way back in September of last year, so it doesn't look like.
Right, and we'd never had a meeting. I didn't even know that that was so.
I don't even have a file in my system.
All right, okay, so
I mean, by all means, if I do have help, I would love to take advantage of it.
all right, so sir, you're James Laverne Thomas.
Correct.
Mr. Thomas, the information I have is that you have a monthly child support charge of $418, and you have an arrearage in the amount of $29,829.24. Do you understand that?
Yes, I do understand that.
Do you understand there's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes.
Do you understand that if you were to plead guilty to that offense, that I could sentence you to jail for up to 30 days?
Yes, I understand that.
You're entitled to have a trial, and you can't be convicted at that trial unless the evidence proves that you are guilty beyond a reasonable doubt. Do you understand that?
Yes.
You are entitled to have an attorney represent you here today and at any other proceedings. You have spoken with Ms. Underwood, so do you understand that?
Yes.
If you want an attorney, you don't have the money to pay for one, you can tell me that and I can appoint one for you at public expense. Do you understand that as well?
Yes.
And I presume at this point you'd like to be represented by an attorney.
Yes.
Do you have the ability to pay for your own attorney?
No.
Okay, so I will appoint the public defender's office to represent you. And as I've indicated, you have already spoken to Ms. Underwood. I presume Ms. Underwood, you want to enter a not guilty plea at this point?
That's correct, Your Honor.
All right. Okay, so what I'm going to do is I'll set this out for 2 weeks. So to March 13th on the condition that Mr. Thomas make the $400 payment today that he's indicated that he can make. This is obviously a very high arrearage case. And I would also indicate that Mr. Thomas's monthly charge is $418. So the payment he's agreed to make today does not cover even his entire monthly charge, let alone starting to address the arrearage. And that is what Mr. Thomas is going to need to do in order to prevent this situation from moving further down the road. Again, given the high amount of the arrearage, that needs to start happening quickly. I'm actually surprised at this point that the Attorney General hasn't taken up this case, but we need to start seeing payments that reduce that arrearage amount. And so, Mr. Thomas, that's what you need to do, and that's what I'm going to be asking.
I do understand that, Judge. It was a very hard winter, and my work has considerably amped up, and I do anticipate having considerable payments coming in the near future.
All right, so we're going to check back on March 13th to see where we are in that process.
In the meantime, should I meet with Ms. Underwood?
Mr. Thomas, call my office and we'll set up a meeting.
That would be great.
264-5353.
Okay.
Thank you.
Thank you.
Okay, Mr. Thomas, you can log out.
Okay, thank you, Judge.
Okay, Ms. Underwood, had you been appointed for Erica Bowman?
What was the name, Your Honor?
Erica Bowman?
I have an Erica Whitman.
Yeah, that's the same person. All right, Ms. Bowman, are you there?
Yes.
All right, Ms. Bowman, I'm going to place you in a breakout session with Ms. Underwood so that you can have a private conversation with her.
Okay.
Okay, we can do Tripp versus Caceres. All right, we're on the record in Linda Tripp versus Andrew Caceres. It's file number 16-42941-DS. Today is the date set for a hearing on an objection to a referee's recommended order. We are proceeding today by video conference. Miss, you are Linda Tripp.
Yes, Your Honor.
And sir, you are Andrew Caceres.
Yes, Your Honor.
All right, so Ms. Tripp, this is your objection to a referee's recommended order regarding parenting time. I've read it. You can proceed with any other argument that you have at this time.
Yes, Your Honor. I do not want him to get parenting time. The only times that he has been with the child has ended in very bad situations where the cops have been called and have been at my house. The only time he wanted to see her, he tried kidnapping her and locked her in a truck by herself. I don't think he deserves parenting time. I have been there for her through everything that she has been through, hospital visits, doctors, losing her teeth. I have been there. All the birthday parties, I was there, and he just did not want to see her. At this point, he abandoned her.
All right, Mr. Caceres, is there anything you'd like to say?
Yeah, Your Honor, most of everything that she just named off was false. I was never invited to no birthday parties. I wasn't even able to even be in the same vicinity of her because she was getting PPOs put on me and all types of stuff. So there was really no way for me to actually go and reach out if I did want to at that time. Also, at the time that when she was young, I had a lot of warrants out for my arrest, and I wasn't in the right mind state to actually be around a kid and be helpful to a kid. You know what I mean? I was on the run. I was using drugs at the time, but ever since my last incarceration, I have got out. I got a job. I started paying my child support. I am on drug court currently right now in Lenawee County. I'm almost done with that. I'm on phase 3. I have my own house. You know what I mean? I'm for the first time in my life, I'm actually stable to where I can benefit a kid and take care of a kid. You know what I mean? And I just feel like she's my daughter. She's my daughter, so I would like to be in her life. Also, I'm having another kid on the way right now, so I feel like she has the right to know her father and her sibling. You know what I mean? And all I'm asking is, it's not like I'm asking for half and half. All I asked the referee hearing lady is that I'll start out at the lowest totem pole on the visiting situation, and I'll work my way up. And that's it, Your Honor.
All right, so the referee's recommended order in this case was for supervised parenting time. Under Michigan law, it's presumed that it is in the child's best interest to have a relationship with each parent unless it's proven by clear and convincing evidence otherwise. And I don't think that in this case that has been proven. Obviously, there are difficulties and concerns here, but I think that as a first step, that supervised parenting time addresses those concerns, because there will be someone there to watch over Mr. Caceres during his parenting time and ensure that it occurs appropriately. And if it doesn't, that person can report back to the court, and the court can intervene at that time. So I don't believe that the referee erred in making that decision, and so I'm going to deny that objection and allow the referee's recommended order to stand. I will issue a written order to that effect. You can both go ahead and log out.
Thank you, Your Honor.
Thank you. Okay, Ms. Underwood should have Ms. Bowman back here in just a moment. All right, so we are on the record now in file number 07-32177-DM. Owen Whitman versus Erica Bowman, formerly known as Erica Whitman. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Ms. Bowman this morning, Your Honor. I have no recent documents for Ms. Bowman other than from last fall, but Ms. Bowman is having $190 some taken out of her check, Your Honor, and it has been since at least November.
Okay, so this is exactly the issue we addressed at the last hearing, and Ms. Bowman was supposed to provide documentation to the friend of the court that money is being withdrawn, because that money is not getting to the friend of the court. At least it wasn't as of the last hearing.
Okay.
So do we have any verification of that yet?
Yes.
Can you provide the friend of the court with check stubs indicating that that is being withdrawn?
Yes. Yes, I can.
Okay, so I'm going to say again, that is what was supposed to have happened for today's hearing.
Oh, okay.
So I'm going to give you one more 2-week adjournment to do that with the friend of the court. If you don't do that, I'm just going to set this for trial, because you've had a month now to get that information to the friend of the court.
Okay, I understand.
So we'll adjourn this to March 13th at 8 a.m.
Okay, thank you, Your Honor.
Thank you, Your Honor.
All right, Ms. Bowman, you can go ahead and log out. Okay, Ms. Underwood, we have Stephen Stickler here. You have not spoken to him yet, and we will email you his information right now. Can you run this out to Stephanie and ask her to email it to Underwood? Thank you. To Stephanie Law. All right, Mr. Stickler, I'm going to place you in a breakout session with Ms. Underwood from the Public Defender's Office.
Thank you, Your Honor.
Jose Ramirez. All right, we are on the record now in the people of the state of Michigan versus Jose Feliciano Ramirez. It is file number 10-15129-FH. Sir, you are Jose Feliciano Ramirez. Mr. Ramirez, can you hear me? All right, Mr. Ramirez, are you able to hear me?
Hello, sorry about that.
No problem. You are Jose Feliciano Ramirez? Can you hear me, sir?
Hello?
Mr. Ramirez, can you hear me?
Yeah, I gotta hold it up to my ear. I don't know why it's not connecting to my speaker.
All right, just make sure your volume's all the way up.
Okay, yes, it is, Your Honor. I apologize.
All right, you're Jose Feliciano Ramirez?
Yes, Your Honor.
Okay, Mr. Ramirez, we're here today for a hearing on your application to set aside a conviction. We don't at this point have the letter that we need from the Attorney General's office or your criminal history report.
Judge, if I can interrupt.
Yeah, go ahead.
I just sent you a chat message about this case. I do believe Ms. Bruggeman received that this morning.
Okay. All right, Mr. Ramirez, would you raise your right hand, please?
Yes, Your Honor.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor. Yes, I do, Your Honor.
Okay, and you are Jose Feliciano Ramirez?
Yes, that is a fact, sir.
Mr. Ramirez, you filed an application to set aside a conviction in this case. Is that correct?
Yes, that is correct, Your Honor.
When you filled that petition out, is everything in that petition true and accurate?
Yes, Your Honor.
Okay, I'm going to let Ms. Bruggeman ask you a few questions, and then I'll give you an opportunity to say anything else that you like.
I understand, Your Honor. Thank you.
All right, Mr. Ramirez. So you're seeking to set aside one felony, possession of a controlled substance from 2011. Is that correct?
Yes, that is correct.
And is that the only felony conviction you have?
Yes.
And I see you have some other convictions from other counties, it looks like. Are those all misdemeanor cases?
I believe so, yes.
Okay. And have you sought to set aside the misdemeanor convictions in Lenawee?
I don't think I have done that.
Okay. You're just seeking to set aside this felony at this time. Is that correct?
Yes.
Okay. And I see that according to your criminal history, the last conviction that I show for you is from 2015 for some it looks like some driving offenses, failure to report an accident. Is that the last time you received a conviction?
Yes.
Okay.
Yes.
And so since that time, or since even the time that you received the conviction for your the drug offense that you're seeking to set aside here today, what have you done in your life to change your life around?
I have my kids to thank for that. My two boys, raising them has been a massive change in my life, and it's also in job wise, it's kind of hindered me from getting jobs that I would like to pursue. But I am working right now at Mylan Factory JTech. I've been here for about 6 months now, but before that, I was a floor technician.
Okay, and so you indicated that it's impeded, this conviction has impeded you from either advancing in career options or getting certain job opportunities, is that correct?
Yes, that is correct.
Okay, and do you have any pending criminal matters in this state or in any other state?
Not that I am aware of.
Okay, do you know of any that you're being investigated for?
Oh, no, definitely not.
Okay.
No, I've actually been doing really good in life.
Okay. And again, everything on your application that you submitted to this court is true and accurate. Is that correct?
Yes.
Right. Your Honor, I don't have any other questions. As Sierra indicated, we received the Attorney General's letter this morning for Mr. Ramirez's case indicating he does qualify under the statute. It appears from his lien, he has various other misdemeanor convictions, and this is the only felony that I see on his record. At this point, based on his testimony, I would just leave it in the court's discretion.
Thank you. It does appear that Mr. Ramirez meets the statutory qualifications to have his conviction set aside. He has testified here today that the conviction being on his record has hindered his ability to obtain employment or advancement in his employment. I think on that basis, it would be in the public interest to set the conviction aside. He has gone a significant period of time without any further interaction with the criminal justice system, and I think that it is good to have him have the ability to pursue his employment without the felony being on his record. So I'm going to set the conviction aside. Ms. Bergman, are you able to prepare an order for the court to sign? You were.
Sure. Yes, thank you.
Okay, thank you very much then. Mr. Ramirez, you are all set. You can go ahead and log out.
Thank you, Your Honor. I appreciate everything.
Okay, have a nice day.
You as well. Thank you.
All right, we have Ms. Underwood and Mr. Stickler back from the breakout session. Ms. Underwood, do you know how Mr. Stickler would like to proceed today?
Your Honor, I would ask the court to enter a not guilty plea. Mr. Stickler has a friend of the court hearing scheduled for March 27th on both the issue of custody and child support, Your Honor, that he has filed. This is, I gather, a rather recent order, and Mr. Stickler objects to both parts of it. So, and I've told Mr. Stickler that he probably should start making some payments, Your Honor, so that he doesn't have, no matter what's decided, so that he doesn't have a huge arrearage. And I think he will do that, but we would ask for this to be adjourned till after the 27th.
The hearing you said was March 27th?
Oh, that's what I have on my paperwork, Your Honor.
All right, so I'll adjourn this to April 3rd at 8 a.m. So April 3rd at 8 a.m., Mr. Stickler, you will need to log back in at that time or be here in the courthouse in person. Either way is fine.
I'll be there in person, Your Honor. Thank you much.
All right, thank you.
Thank you.
Okay, Ms. Underwood, I don't have anyone else that's related to a friend of the court show cause. Is everyone here now for a friend of the court show cause hearing? Okay, I don't
Thank
have
you, Your
anyone else
Honor.
logged in on those. But we've got a few others to take care of. Do Nicholas Edwards, Scott versus. Right, we are on the record now in Stephanie Scott versus Nicholas Edwards. It's file number 19-46299-DS. Today's date set for a hearing on an order to show cause. We are proceeding today by video conference. The gentleman just came in the courtroom. Can you tell me your name, please?
Art Thompson.
Okay. All right, the record should reflect that this matter was set for an order to show cause this morning at 8 a.m. It is now 9:38 a.m. Mr. Edwards was ordered to appear and he has failed to do so. I am going to issue a bench warrant for his arrest and set bond in the amount of $2,468.97. Ford versus Hall. We're on the record now in Janae Ford versus Ricky Hall, file number 11-36642-DM. The record should reflect this matter was set for an order to show cause this morning at 8 a.m. Ricky Hall was ordered to appear. He has failed to do so. He's not present in the courtroom. He's not logged into the Zoom session. I'm going to issue a bench warrant for his arrest and set bond in the amount of $12,112.09. Versus Clunk. We are on the record now in the matter of Robert M. Hoot versus Kelly Lynn Clunk, file number 04-27743-DP. Today's date set for a hearing on an order to show cause. The record should reflect this matter was set for a hearing this morning at 8 a.m. It's now 9:40 a.m. Mr. Hoot was ordered to appear and he has failed to do so. I am going to issue a bench warrant for his arrest and set bond on the bench warrant in the amount of $5,529.12. Versus Cope. We are on the record now in Margaret Elaine Key versus Thomas Henry Cope, file number 09-33573-UE. Today's date set for a hearing on an order to show cause. The record should reflect this matter was set for a show cause hearing this morning at 8 a.m. Mr. Cope was ordered to appear. It is now 9:40 a.m. and he has failed to appear. He's not present in the courtroom. He's not logged into the Zoom session. I will issue a bench warrant for his arrest and set bond on the bench warrant in the amount of $10,259. So, do you show cause? Ms. Stevenson, we had Alicia Cutler versus Stephen Johnson on our docket today, but I didn't have any information on him.
Yes, Your Honor, it looks like the caseworker has adjourned that out until March 20th.
Okay.
Thank you.
All right, I think that's all of them then that I had, unless I missed something on your end.
We're all set. Thanks so much.
Okay, thank you. All right, good morning, Mr. Feldman. I do not have Mr. McCardle logged in. Have you heard from him at all today?
We spoke by text on Friday, so he's aware of the hearing, but I have not heard from him this morning, Your Honor.
Okay. See, we'll try to contact him. Do you want to call? I'm going to put you back in the waiting room for a couple minutes and we're going to try to track him down.
I'll text him as well, Your Honor.
Okay, thank you.
Thank you.
Is there Mr. Sorensen here? No. I would go on record in People versus Sorensen. All right, we are on the record in the People State of Michigan versus Timothy Sorensen. It's file number 14-17032-FH. We are here today for a hearing on a petition to discontinue sex offender registration. We are proceeding today by video conference and in person. Ms. Brugman, would you like to place your appearance on the record?
Jennifer Bruggeman on behalf of the people.
All right, the record should reflect that this matter was set for hearing this morning at 9:30 a.m. It is currently 9:45 a.m. Mr. Sorensen is not logged into our Zoom session and he is not present here in the courtroom in person. I have read and reviewed his petition to discontinue the sex offender registration, and I have read and reviewed the people's answer to that petition. Ms. Brugman, is there anything in addition to your written submission that you'd like to say?
Just since I filed that answer, Mr. Sorensen also did a reply. I don't know if the court received that. But I don't believe anything that he's mentioned in his reply applies. The statute is pretty clear on what is required to ask the court to discontinue sex offender registration. And since he's a tier 3 offender and given the circumstances of the offense, none of the exceptions, if you will, apply here, as well as it has not been 25 years since he was sentenced or released from probation, parole. So at this point, again, I would ask the court to deny the petition. Mr. Sorensen in his reply brings up a lot of the case law that's come down over the past few years regarding the constitutional nature of SORA, but those cases, the changes that were made to SORA, that based on those cases and what was constitutional and what still is, or what's unconstitutional, is not applicable here. So again, I would ask this court to deny the petition.
Okay, I was not aware that Mr. Sorensen had filed a reply brief. I have not seen that, and I don't seem to be able to access it through our computer system at the moment. So what I will do is I'll take this under advisement, and as soon as I've had a chance to read his response brief, I will issue a written order.
Sorry, sounds good. Thank you, Your Honor.
Okay, thank you very much. He said he's not objecting.
I apologize. I can be in about 5 minutes.
Oh, I'm sorry. Let's see. Sir, you're Stephen Johnson?
Yes, I'm sorry, I got disconnected, so I joined again, and apparently it left me out the whole room.
Okay, so Mr. Johnson, when I got to your case, the friend of the court caseworker indicated that that had been adjourned, and she told me the new date, but I can't remember it now. So you'll need to contact your caseworker to find out what your new date is going to be.
Okay, I will. And I'm just gonna go down there and make a payment as well. That's what I was hoping. I just wanted to have a hearing first, but I'm gonna go down in between time and make some type of payment.
Okay, yeah, and obviously the more payments you make, the front of the court caseworker may decide to dismiss it altogether. So
Right.
that'd be a great.
So I will contact her. Thanks a lot.
Okay, thank you very much. Okay, we are on the record now in, I'm sorry, Mendizable versus Synchrony Holdings, the 950. All right, we are on the record now in Jacob Mendizable versus Synchrony Holdings LLC, file number 22-226953-NO. We're here today for a hearing on two motions, plaintiff's motion to compel discovery and the plaintiff's motion to strike a notice of non-party at fault. We are proceeding today by video conference. Mr. Feldman, would you like to place your appearance on the record?
I would, Your Honor. Stan Feldman representing the plaintiff, Jacob Mendizable.
All right, the record should reflect that Mr. McCardle, the attorney for defendant, is not logged into the Zoom session and not present here in the courtroom. My court recorder has had some email correspondence with him. He has indicated he's not objecting to these motions and that we are able to proceed without him. He is in another hearing at the moment. So Mr. Feldman, is there anything you'd like to say in addition to your written submissions?
Other than the fact that we have resolved the discovery motion by way of a stipulated order, which has been or will be submitted to the court today, the terms of which are 14 days for full and complete responses. That only leaves the motion to strike the notice of non-party at fault, which Mr. McCardle indicated that he's not opposing, though he could not stipulate to. Your Honor, in full disclosure, I'm just seeing a text from Mr. McCardle that says, I am in another hearing now, will hop on shortly, I'm not opposing. I'm not sure if he was planning on jumping on to say the same, or if that somehow crossed with the email that you mentioned your staff received from him. But if he was planning on jumping on the call, I wanted to make sure that he was given the opportunity to do that, even though I think that I fairly represented what his position is or the lack of position is on the motion.
Okay, I can pass this for a few more minutes and wait for him to get logged in then.
Yeah, let me just confirm with him by text. Is he coming or is he not coming? His text to me says he's in another hearing now. We'll hop on shortly. I'm not opposing, but that's different than you can proceed and I'm not opposing and I won't be coming. So let me try and straighten that out, Judge. I apologize.
As you were speaking, he popped up in the waiting room. So let's bring.
Oh, great. Thank you.
Okay, we do have Mr. McCardle here now. We are on the record in Jacob Mandisible versus Synchrony Holdings LLC. Mr. McCardle, would you like to place your appearance on the record?
Thank you, Judge. Robert McCardle appearing on behalf of the defendant.
Okay, and so we had been on the record shortly before you popped up in the waiting room, Mr. McCardle. And I had indicated that we had some email correspondence with you that indicated that you were not opposing the motion. It's my understanding that the motion to compel discovery is being resolved by a stipulated order, which leaves only the motion to strike the defendant's notice non-party at fault. But now that you are here, I'll give you an opportunity to say anything you would like with respect to that motion.
I won't waste any more of the court's time, Your Honor. You just indicated exactly our position. The motion to compel, we've agreed to a stipulated order with Mr. Feldman. The motion to strike the non-party fault, I am not opposing, Judge.
All right. Based on that, I have read and reviewed the motion to strike the notice of non-party at fault. I think it does adequately or correctly state the law that applies to the issue. I think it is appropriate to strike the notice on that basis. So I'm going to grant the motion and strike that notice of non-party at fault. Mr. Feldman, I will sign a written order to that effect if you will prepare and send one to the court if you haven't already.
I will do so. Thank you, Judge. Morning, Bob.
Morning, Stan. I apologize for my tardiness.
All right.
No problem. Okay. Thank you very much.
Thank you, Judge.
Thank you, Judge.
All right, Mr. Daly, you're here for Mr. Moeller.
Yes, Your Honor.
All right, and Mr. Moeller is present here in the courtroom. So we are on the record in the People's State of Michigan versus Stanley Leroy Moeller, file number 21-20225-FH. Today is the date set for a hearing on a motion to be released from probation. We are proceeding today by partially by video conference and partially in person. First, let me ask the attorneys to place their appearances on the record. Ms. Brugman, okay, you're appearing on this one?
Yes, Your Honor. Jennifer Buggerman on behalf of the people.
James Daly on behalf of the petitioner, Your Honor.
All right, Mr. Daly, this is Mr. Moeller's petition to be released from probation. You can make any oral argument you have at this time.
Yes, Your Honor. On July 1st, 2021, the defendant was placed on served 60 days in jail, paid fines and costs, and placed on probation for 36 months, with one of the conditions of probation being a curfew from 10 p.m. to 6 p.m. The defendant has completed everything successfully on his probation. He's had no violations. He's had no curfew violations. He's had no violations of any sort. understands the consequences of what he did, and he's shown by every way that he can that he is complying totally and completely. But right now, this is affecting the defendant's ability to be promoted and to travel in the course of employment. This is causing him to lose the potential to be advanced in his position. And he can't do that if he's under these current restrictions for traveling out of state for short periods of time. These trips come up frequently, and they're of short duration and really of a short time to give notice. And based upon these facts, based upon what has happened with this probation officer, and based upon the relationship that Mr. Stevenson has developed with this defendant, for all of these reasons, we would ask that he be released from probation and his case be closed.
All right, Ms. Brugman?
Thank you, Your Honor. I filed a response, and the victim, one of the victims, Michael Crater, is in the courtroom, and I believe would like to speak. Under the statute, a victim is entitled to notice and to appear at the hearing. I will state briefly that in my conversations with Michael Stevenson, the probation officer, and also in just reviewing Mr. Muller's file, as far as complying with probation terms, it does appear that he has. I would just, and he's also completed more than half of his probation. So technically this court does have the authority to amend or release him from probation. At this point, in talking with Mr. Crater, and he can speak more to his thoughts on it. The main issue here is maintaining no contact with between Mr. Muller and Mr. Crater and his son, Brent. Mr. Muller was originally charged with home invasion, first degree, and along with some other offenses. And Mr. Crater, while Mr. Muller has not violated in terms of contacting him, he is quite concerned because he is his neighbor, concerned about that could occur. And he really has no other issue with the court amending Mr. Muller's probation terms for employment purposes and things of that nature. It's just merely an issue with maintaining that no contact. Mr. Crater had originally asked this court to issue a permanent PPO, which I don't believe was done. But I think, again, I think this court has the authority to amend the probation to really only impose that kind of a term, a no contact term, and really wouldn't impede Mr. Muller in that regard, and also protect Mr. Crater and his son. So that would be my request at this point. And if Mr. Crater, if the court is inclined to hear what Mr. Crater has to say, I believe the statute does allow that.
All right, Mr. Muller, you want to have a seat there, and then Mr. Crater, if you want to come forward and just first state your full name and then whatever it is you'd like to say. Go ahead.
Michael Ray Crater, and she said it just perfectly. My son and I would like to have the no contact continued forever if possible.
Okay, anything else?
No, this has impacted my son much more than me. He's not the same son that I used to know. He's done things to make sure he's self-protected, and we don't want anything to occur. We just want to be left alone, and we don't want the gentleman on our property at all, for our own safety.
Okay, thank you, sir.
Thank you.
All right, so Ms. Brugman, you indicated that you did file a response.
I did, Your Honor. It was unfortunately probably last Wednesday. I imagine Tuesday, Wednesday, somewhere in that time frame. Actually, it's dated. I dated it the 22nd. So yeah, that would have been last Wednesday.
All right, so due to the 2 days worth of power outages that we had last week, that response didn't make it to me and it's not in our computer system yet. So I haven't had a chance to review it. I do like to be thorough and make sure I read everything before making a decision. So I'm going to take this under advisement. I'll read Ms. Brugman's brief and then I will issue a written order with my ruling.
Thank you, Your Honor.
Thank you, Your Honor.
All right, thank you.
Your Honor, I think I'm done in your court, but the calendar's been all over the place, so I just want to make sure.
No, I'm pretty sure that's all I've got for you. Thank you.